The legislature is back in session. We left off with bill number 239, so number 253-31, COR, and I recognize the author, Senator Chris Dueñas.
Buenas tardes, Madam Speaker. Dan sejus masih pada esti na oportunidad. Malaguzu ta pega esti Bill 253-31. Gimi na tres na tinaitay. Sa malaguzu lo kita diskuti esti na pinaponi. Thank you very much, Madam Speaker, and good afternoon. I would like to place Bill 253 in the third reading, and I'd also like to discuss it, Madam Speaker. Madam Speaker, Bill 253 is, I believe, very timely, and I'd like to start by thanking you for joining me in this piece of legislation as my co-sponsor. Over the last several weeks, there has been discussion in the media surrounding zoning issues and concerns with regard to the legislature's activity in rezoning properties. I would like to say, Madam Speaker, that first of all, in my short stint as the Director of Department of Land Management prior to seeking elected office and becoming a member of this legislature, I used to receive a number of correspondence by one of our colleagues, Speaker Ben, who of course has been the chairman for land for some years now. And I really appreciated it because Department of Land Management consistently had an opportunity to comment on bills being proposed by this legislature to rezone property. And I commend his efforts in that vein. And it was actually through that process that I thought about doing this, to actually put it into law, that practice, in order to ensure that this legislature, understanding that it has the responsibility and the final authority on land matters, also really should have and be well informed in terms of the potential effects of rezoning property through this means. As you know, Madam Speaker, the Department of Land Management, Guam Land Use Commission, is very capable and does a very thorough job when applications are placed at land management for the rezoning of property and other variances. And also, Madam Speaker, I would just like to say that having served also as the collateral duty as the Director of Land Management, as the Secretary for the Guam Land Use Commission, there were times when we wouldn't have quorum. There were times when sometimes 2 months would go by because of scheduling conflicts, off-island travel, and the like, that we didn't have quorum. So I understand sometimes when the legislature needs to introduce legislation for rezoning as a matter of expediency. Especially in critical areas, sometimes this may exist whereby investors, their project is time sensitive and a number of other reasons. But in most instances, sometimes, Madam Speaker, and we must admit that sometimes it's simply to bypass the process. And the unfortunate circumstance when that happens is the general public, and especially those with adjacent properties, do not have the opportunity to give their input, to object if they would like to object. And also there's sometimes just not the opportunity for mitigating efforts to be put in place. So that even if an individual didn't like the fact that a property would be rezoned, and even if the Guam Land Use Commission would probably even do it, if it went through the regular process, at least when it goes through the Guam Land Use Commission, they put a number of conditions oftentimes in order to ensure that the public's concerns are met. A lot of times that has to do with infrastructure. A lot of times that has to do with the use that's being applied for. A lot of times they will change perhaps a commercial zone to a conditional use just because commercial is very liberal in terms of what type of activities are allowed. So it's these examples, Madam Speaker, that I bring about and bring up. And as it says, as it's set up in Bill 253, essentially what happens is members of this body will be required to obtain a report from Department of Land Management before moving forward and reporting out the bill and having it being debated on this floor, so that we could be educated, Madam Speaker. And also so that in the event that it just does not look very favorable at all, what's being proposed, perhaps that bill gets pulled back and we simply make the recommendation that these individuals go through the Guam Land Use Commission in order to ensure that this process can go through properly. Madam Speaker, I know that you yourself and others have dealt, even in this session, with pieces of legislation that regard rezoning. You've requested for the maps, you've requested for the information, and we've debated it heavily on this floor. Madam Speaker, should this bill pass and be signed into law, it will just give us that one more tool, besides just the map, besides maybe a few comments from the public hearing, but true commentary from the land professionals, who is the Department of Land Management and the Guam Land Use Commission. So, Madam Speaker, I thank you once again for the opportunity to speak on this bill. I certainly hope that I can get the support of my colleagues. And at this time, I will listen to the debate and look forward to it being voted on sometime in this session. Sijus Masi, Madam Speaker.
You're very welcome, Senator. On the motion, is there anyone who would like to speak on the motion? Got Senator Pangilinan and Senator Gutter. Is anybody else? Keep your hands up.
Thank you very much, Madam Speaker. Madam Speaker, conceptually, I have no objection to the bill. I mean, this is something that we do today, that this committee has decided and implemented a procedure that sends out these notices to each of the departments that are members of the Application Review Commission on any rezoning proposal. So this doesn't change anything, except it puts it in statute now. But on the other hand, it really does, I think, hamper the work of the committee, because we're no longer, from what I see here, and if I read it correctly, plus it kind of infringes on the legislative process and the ability of the committee to schedule public hearings. If I read this correctly, we can't have a hearing without those reports, and when those reports are on file, then nothing else matters. We just move forward. So what is our intention? Is it to bring the information, or just to require the information? Because, you know, right now we do that, but again, the way this is written, the committee cannot hold a hearing until 60 days, basically, or until Department of Land Management decides to respond. So if they decide to respond on the 59th day or the 45th day, then we can't do anything. And I'm not sure that that's the intention, but it certainly hampers our ability. And then we also have a standing rule that says if the committee doesn't hold a public hearing in 90 days, then it becomes the jurisdiction of the author. And so if we're going to provide to hamper the committee from doing its work to comply with the regulation, with the standing rules, then I think we should exempt the committee from that section of the standing rules, so that anybody, and I think we should make this the author's responsibility. You know, I mean, I do it because I think we should, but I think if the author, if we're really concerned about these things, then the author should follow up on these requirements for consideration by the committee, rather than the committee be required. But I don't mind. Either way, I do it. We call the authors, we call the departments, we call the agencies, we call the mayors for the resolutions of the municipal planning councils, because we think that facilitates an informed member of this body when we present it to them. But when they don't respond, you know, then we have to move forward, or we make a decision not to move forward. But this says we can't move forward until the agency submits those reports. So I think that maybe the issue is that it shouldn't get on the floor without those reports, but we can hold the hearing. Because, you know, at that hearing, it could be presented at the hearing. And then again, I go back to this, if we don't get the information and so forth, then we have to wait, and then the 90 days runs out, the committee's not in charge anymore, and now, does it wipe out all the other requirements? I don't know. So I think those kind of issues need to be worked out, and I think and certainly would wish that the author would give those considerations. The other thing that I want to point out is that I would like to just make the amendment that on page 2, you have on line 18 that it's the head of the department's application review committee. That's really, for me, that's not who I want to hear from. I want to hear from the member of the application review committee, because this kind of gives the head the ability to kind of waive the application review committee, because we're just looking for the review of the head. Is the intention here, what is the information that's given to the application review committee by its members to the Guam Land Use Commission for consideration? That's the information, not what the head of the Department of Land Management says about it, because that's who the head of the department's application review committee is, the director. But that's not what we want. Or is it? Is it just to give that discretion to the director and never mind what the application review committee says? Or is it the intent that it is the application committee review report that is what we want, because from the presentation they're saying that's who we want because those are the experts. But now we're just going to give it to the director, who is the political appointee, who may not be an expert. And so I think all of these things, I think, need to be looked at, considered, and while I do support the bill, I don't know that I can vote for it without those issues being resolved. Thank you very much, Madam Speaker.
Thank you, Senator. On the amendment, which is on line 18, page 2, to change the word from head to the member of the department's application review committee. On the amendment, no objections? Yeah, that's the one on line 18. The head, where it says the head, right?
Yeah, but not the departments. The application review committee.
So what line is that? There's
The
two.
department is the application review committee is within the Department of Land Management, composed of representatives from the different departments and agencies.
So the one that we're
So
talking about.
it would be from the application review committee. So take out head of the departments.
Okay, so it's so we're taking out, deleting in line 18, the head of.
No,
Oh, no?
remove head of the departments and just put the application review committee.
Oh, the application review committee. Okay, so.
That's correct.
Okay, so no objections? So ordered. Thank you, Senator. There's something else you had discussed earlier, but maybe can leave that to after.
Unless a recess, Madam Speaker, but I just wanted to make a point of information just real quickly.
Please state your
The
point of
section
information.
below what's outlined in terms of the report, Madam Speaker, clearly kind of corrects the opening land zoning consideration reports required for land zoning legislation. On line 5 of page 2, if you go to line 11, here's where we basically allow for, it almost seems contradictory, but it's because it outlines what is required in section C. But we did correct ourselves here, saying failure for the department to provide a land zoning consideration report to the appropriate legislative standing committee shall not preclude the standing committee from publicly hearing or reporting out of committee any bill. And so essentially you can move forward here almost simultaneous as long as you're understanding the timely response and submission given in Section C.
Yeah. Okay, we're going
Yeah, Madam Speaker, just for the record, it's the failure of that, and they have 60 days to fail. So the committee, if it was following what I was saying, it's the fact that it hampers the committee's work. We can't have a hearing until after the 60th day. That's what I'm saying is the problem here. So that I can't do a hearing until they fail to submit the report, of which they have 45 days and then 15 days automatic grant of an extension.
So we're going to take a brief recess. In session on the, Senator Pangilinan had spoken, and the chairman would address, I think, the concerns of the previous speaker when he closes. So on the motion, I have Senator Guthertz.
Thank you, Madam Speaker. You know, the bill is a very interesting bill and probably does no harm. But, you know, I think there's really a bigger question, and I've always wanted to ask this question, but I could never really get a coherent, reasonable response, and that is, why do we do this at all? We have the Land Use Commission that by law is supposed to be taking care of matters brought to it, and yet folks still come to the legislature for help. Many of them crying for help, feeling that the Land Use Commission has not been responsive or prudent in considering their requests, and in some cases just people avoiding the Land Use Commission altogether. So I just want to present that to the body, that perhaps it's time for the legislature to review the statute that created the Guam Land Use Commission and review what maybe some of the gaps are and find out how we can deal with those gaps. Because I personally have seen a lot of things come before the legislature that really has bothered me over the years regarding zone changes and things of that nature. But of course, those that come to us for help feel that they have not been properly attended to at the Land Use Commission. Another point, Madam Speaker, is that I'm not certain that what the Land Use Commission does is exactly perfect anyway. Because they've made some decisions that have upset sectors in the community in rezoning property, allowing for less green spaces and more parking spaces and higher buildings than normally authorized and things of that nature. So I think all around there's a need for us to look at how we're handling issues of land and zoning, whether by the Land Use Commission or by the legislature, and see what we can do to straighten out the situation. Thank you very much.
You're welcome, Senator. On the motion, is there anybody else who would like to speak on the motion? There being none, then I'm going to ask the author if you would like to close. Senator Duenas.
Thank you, Madam Speaker. Certainly a very intriguing question from the previous speaker. And as I said at the outset, Madam Speaker, it really is, and I once again want to commend Speaker Ben. This really is, as he said, to put into statute what he already does. And like many of us here, we don't know our time. We may be here another 2 years, another 10 years, another 20 years. We may not. And so maybe the good speaker's practice, wouldn't be carried on from the next chairperson whenever that time might be. So that is one of the reasons why I wanted to take that good practice and put it in statute. And I thank him also for clarifying the issue of it is the application review committee and their comments that really matters. And that change really did make a big difference here. So I thank him for that. And I also thank him for the opportunity to ensure that we can move forward and not hamper the committee's work. And I did work with the clerk, and we have deleted that line, Madam Speaker, to ensure that the process can go forward. However, we will not deliberate on the floor here until those comments have been included, so that we may have an opportunity to receive as much information as possible on the consideration here. So, Madam Speaker, I certainly appreciate the opportunity, and I thank the members of this body for making this a better bill and something that I believe will make a difference, a big difference in how we deliberate on proposed legislation that stands to rezone property by this body. Thank you very much, Jesus Masi. Oh, okay. Thank you very much. I thought that it was okay. So I will move at this point, Madam Speaker.
But before you do that,
Yes.
Should I just, I forgot that the co-author of this legislation with you,
Yes, ma'am.
Senator Dueñas, would like to speak on the main motion.
Okay.
So before you make that deletion, maybe I'll just go ahead and give you the time to make that deletion after she speaks. I'll give her that opportunity
Excellent.
since there's a motion in there.
I'll
Speaker
reclose.
It just gives you extra time, Senator Dueñas. I'll give you a chance since it's Christmas. Speaker Wampat, you're acknowledged on the main bill.
Thank you very much, Madam Speaker. I know I was actually trying to find the Vice Speaker at the time and didn't realize that I had called upon the primary author to close, and I wanted to speak briefly on the bill. I know that very early on in the year, the Senator and I have actually spoken to some degree about, our thoughts about this whole process of rezoning, and because he was previously as serving in that department as the director, had seen also the process. And that yes, this is an authority in which this legislature is not willing to give up. And and I guess primarily because, for one thing, is we really don't even have a master plan at all for the entire island of Guam, which saddens me, of course, because I actually sat through that whole process. It took months. I remember it on the 24th Guam Legislature. And all that time, and then ultimately, we were shy one vote to get it passed. And it's sad because I am not normally in favor of spot zoning. And every time a spot zoning bill comes to the legislature, I always ask for the map. I want to be able to see the map, or I even like to go and visit the site. So normally what I would do at lunchtime would be to run over to the area and look at the actual lot to see then exactly what it is we're voting on, because I want to be sure of what I'm voting on. And if I'm unable to do that, then I try to get a map, a copy of the actual map from land management, and speak always to the author about the rezoning or even the selling of any government pieces of property. If it's very clear on the map, then it's not a real big problem. But if it's not, then I like to get further clarification. So I think in the whole time that I've been in this legislature, I've actually only introduced one zoning bill. And like the author of this bill, my concern was that we have a process. This legislature has created a process, and there's a reason for the process. And that process, of course, will be to try to protect the entire community and make sure that the community benefits from this in terms of, and what it is we're trying to protect here, in terms of primarily our water. Because, a lot of our properties here, they've not been zoned, of course. Secondly, we have people living everywhere. You can find different types of zoning almost in every village. So there's no sense of some type of semblance of, a continuity of zoning, where it's like residential was all residential, agriculture was all agricultural, commercial, and that sort. Whereas you live in a residential area, then you can have a neighbor that has a small shop, automotive shop right there, And an example of that, of course, you can see especially in which we call now the industrial part, where we have, R2 zonings there, and then of course you've got commercial, and then you've got, industrial and all that. And so to get back to the bill that one bill that I've introduced only, was that I've actually gone through the exact same process in this application review process, is that I've asked the owner of the property if they had gone through the list. Have they approached or written to, let's say, EPA to see what they thought about it? Have they contacted the fire department? And they've indicated that they've done, and they have not heard back from them. Then I wrote the letter and wrote to every single one of those individual departments and agencies as well to get some feedback again from them, and held that bill, basically never even bothered to even report it out. And I said at that time, because at that time I was actually the acting chair of the Lands Committee, and only then when, of course, the department just never responded after months of doing this, then that's when I finally had reported the bill out. And then, of course, modified it where it didn't even go at the same level at the original request, but downgraded it even by one level because of my fear that this was something that was so critical to our environment that I didn't want to jeopardize our drinking water, because this happens to be in an area, of course, where all of the residents and are all basically have septic tanks, and that they were not part of our public sewage system. And for fear then that activities, certain type of industrial activities, could then contaminate our waters. And in my discussion then with the author, of course, is that we wanted to make sure then that that either the author or whoever it is that's the owner of the property would actually go through that process by making an attempt to get in touch with these different departments and agencies to show then whether, one, they're more in agreement, or two, that there's an indication of some maybe damage or contamination or what have you. But then we all know that after a bill has been introduced, many times there will be substitutions. And in this case, this bill then was substituted, at great length, because when I first signed off to the original, it didn't have all this extra sections that we currently have, and it kind of surprised me as well. And I'm really, glad that several of our colleagues spoke up, and that's the best part of this whole process, is that when we stand up and give testimonies to these things, that we do listen. We hear, of course, the concerns, and we make our decisions, accordingly. And I think that's what has happened in terms of the amendment. It makes it much better. It gives, of course, still the standing committee chair more flexibility in terms of having to hear a bill. But the most important part of it is that we actually will be getting now this review process that normally any other individual who's going to go through the process with land management can maybe take anywhere up to a year, maybe to a year and a half. And of course, this process is still much shorter, but at the same time, all of the pertinent departments and agencies are responding. And I can understand that on the other side of the coin, Madam Speaker, because I had actually applied for the rezoning of one of my properties and went through the whole process, and it took me a little over a year just going through the normal process. I didn't come to any of my friends here in the legislature to ask them to rezone my property. I went through the process that was created by this body. And it works. Maybe for some others it might take a little bit longer, maybe depending on the type of rezoning. But I think this in itself would really help. It would help me if this was in place in the past, and then even now as we again continue to see more rezonings, that by looking through that application process and getting the input from all those departments and agencies, then I can feel a little bit better now as I vote on any of these rezoning bills. So I ask my colleagues, of course, after that, and with the amendment that we anticipate is going to be coming up, that it would just make this a better bill. So thank you, Madam Speaker.
It's Christmas. Si Zeus Masi, Speaker Wampat. Does my brother want to speak? Senator Blas, I'll go ahead and recognize you.
Thank you, Madam Chair. Madam Chair, this is all, to help the two with regards to the necessary amendments that I'm sure the clerk already has, but we need to formally put it on the floor. To propose the amendments that have already been previously discussed, and that will be found on page 2, starting line 7. Strike out the words publicly heard, reported out by a standing committee of the legislature in Guam, or.
On that motion to delete, are there any objections? No objections, motion carries.
Line 8,
Line 8,
the word
thing.
unless, and delete, replace the word unless with until.
until, on that motion to replace the word less and put in until, no objection, motion carries.
Line 9,
Line 9,
after the Department of Land Management, period, and strike out the words upon the request of the Legislative Standing Committee with jurisdiction of the bill.
say that one more time, Senator Blanc.
Just put a period after land management and strike
delete.
out the words upon the request of the Legislative Standing Committee with jurisdiction over the bill.
On that motion to repeat, to delete, put a period after land management, and then delete upon the request of the Legislative Standing Committee with jurisdiction over the bill. Are there any objections? No objection. What? There is a point of inquiry, Speaker.
The way
Wampat?
the way amendment will read now is any bill that seeks to designate a particular zoning for any real property shall not be placed on the legislative agenda, session agenda, until a land zoning consideration report has been issued by the Department of Land Management.
Oh, okay. Yeah, of course, it sounds better, that is read it. I just wanted to make sure if anything is listed here that that is a mandate to submit this land zoning consideration report.
Yes.
Okay, so that is
Yes.
a mandate. Maybe I'll talk.
So on that motion to delete upon the request of the Legislative Standing Committee with jurisdiction over the bill, are there any objections? No objections, motion carries.
Okay.
We're going to ask for a brief recess.
Okay, wait.
Apologize, Senator Blush, you're recognized.
Thank you,
on
Madam
any
Chair.
more
Madam Chair,
amendments.
in the last set basically of amendments, it's again found on page 2, starting on line 11. Strike out the words failure of the department to provide and replace it with the non-submission of.
I'm sorry, can you repeat that? I'm not your sister now. This
Okay.
is
On line 11, page 2,
line 11, page 2.
strike out the words failure of the department to provide.
Failure of the department to provide. Your proposal is to delete those words.
And replace it with the non-submission of.
Non-submission
of.
Of. So then the motion is to delete failure of the department to provide and replace it with the non-submission of, and then it will read
Okay.
a land zoning
A land zoning
report.
consideration report, and then after the report, put in the words by the department.
Okay, and add the words by the department after
Report.
the report, the word report on line 11. On the amendments, no objections? So ordered.
The last one, Madam Speaker, line 13 on page 2, strike out the words or reporting out of committee.
On page 2, line 13, delete, all in favor, no objections on the deletion of or, reporting out of committee, which shall, then read now the whole sentence.
The whole
first.
sentence will be the non-submission of a land zoning consideration report by the department to the appropriate legislative standing committee shall not preclude the standing committee from publicly hearing any bill as provided in subsection C infra.
Okay, on then the amendment, the last amendment, no objections, so ordered.
And I will, for the sake of not, I will have this photocopied and given to the clerk with mine.
Thank you very much for that, Senator. Now for the final closing, unless there is somebody who just were not given an opportunity to speak again, I'm reconsidering. None? Okay, thank you. So Senator Dueñas, you're recognized and to close.
Thank you, Madam Speaker. Just to complete my closing after all the good amendments were proffered, and you had mentioned, Madam Speaker, which I agree with, that contained in the Application Review Committee is not the Mayor's Council of Guam, and since we're talking about doing this, firming up the report as a matter of legislative rezoning, I would like to add a number 6 to
On page
page
3.
2. Well, it's going to be on page 3, yeah. So we're under B, contents of land zoning consultation report. And so what we would do is on line 10, under 5, put in semicolon and then line 11, we would add a number 6, and the words notification of the Mayor's Council of Guam as being the 6th condition.
Mayor's Council or the Mayor's?
Would it be the Mayor's
You're talking
Council?
about not the council, but I think you're trying to say to the individual municipalities. Yeah, something like that. Notification of
Wouldn't the Mayor's Council, upon receiving the notification,
because each mayor
give
is
it to the
planning
individual
council.
municipality?
So it's the planning council of respective village. Okay, let's take a brief
Okay, brief
recess.
recess.
The legislature is back in session. Senator Dueñas, you still have the floor.
Thank you, Madam Speaker. I think we've come up with some stronger language in terms of the requirements. So, once again, on line 10, we would put the semicolon and the and then 6, starting on line 11, would read, input from the Municipal Planning Council of each municipal district to be affected by a proposed zone change.
Okay? Sounds.
And so that would allow that municipality to have the opportunity and that mayor to have their input whenever we embark on this process.
On the amendment,
I'll bring it to the
Yes.
clerk, Madam Speaker.
okay, yes. So, no objections to the amendment, so ordered.
Si tus masi, Madam Speaker.
And just please, yes, make sure the clerks have a copy of that amendment. So on the motion then to send Bill 253 to the third reading file without any objections, so ordered. Okay, we're now on Bill number, hey, wait a minute. I'm sorry, I made a mistake. I'm terribly sorry, I apologize, my dear. I was reading across, not realizing that there's a next page where 6 follows after 5. So it's Bill number 264-31. Hey, because normally you don't do it this way. Yes, you're right, exactly. And I expected to go to number 6, but it didn't happen. So it's on the next page, so sorry, my sister. I recognize Senator, pura familia, I love families. Bill number 264, I recognize Senator Yamashita.
Thank you very much, Madam Speaker. Madam Speaker, I ask that Bill number 264-31 be put in the third reading file, and I ask to be able to briefly speak to it.
Please, Senator, you may continue.
Thank you, Madam Speaker. Madam Speaker, Bill 264-31 is an act to amend Chapter 9, Division 2 of Title 17, GCA, relative to education and training facilities and opportunities for the individual with a disability. Very, very simply, Madam Speaker, this bill asks to update language. It doesn't change any content. It continues to stand in strong support for respecting all people, particularly those with disabilities. But it does change the words, the vocabulary. Instead of calling the people handicapped, as once upon a time was the correct term, the acceptable term, today we call those who have handicaps an individual of disability. So throughout this particular section of law, any place that we see handicap, we replace it with the individual of disability, as well as a term that we once used regularly, mental retardation. We have replaced that with intellectual disability. And so it's really very simple, really very basic, and again, content is not changed, but labels, descriptors have been changed to ensure that the people with disabilities are accorded the respect and the regard that is due them in 2011. I ask for the consideration of my colleagues to update the language. Thank you, Madam Speaker.
You're welcome, Senator. So on the motion then to place 264 to the third reading file without any objections, so ordered. Number 7, Bill number 223, and I recognize the author. 323, recognize the author, Senator Rodriguez.
Thank you very much, Madam Speaker, and Merry Christmas to you, to my colleagues. Move to place Bill 323 in the third reading file and ask that we can briefly discuss this measure.
You would like to speak on it?
Yes, ma'am.
Please proceed.
Thank you, Madam Speaker. Bill 323, Madam Speaker, is quite simple. If we, for a minute, just put aside but not forget, of course, the passionate testimonies of our people who came forward at the public hearing. I want to thank the Vice Speaker for quickly scheduling a public hearing and reporting this bill out. If we can put those aside for a minute, and also all the rhetoric that is involved in this bill, Madam Speaker, is really simple. If a minor is going to seek an abortion, all this legislation is asking is that a parent or an adult give their consent for this minor to proceed with the procedure. The procedure of abortion, Madam Speaker, is could be very dangerous, and it's a very dangerous procedure. And so we want to make sure that that the parents, if it's a mother or father, a guardian or custodian, is involved in this minor's decision, because what we don't want, Madam Speaker, is a minor to proceed with this procedure and for something to go wrong, and the only time that the parents would be forced to be called is when this minor is in the hospital, and at a time maybe it might be too late. And some say that, well, at the time the minor is already pregnant and she wants to get an abortion, it's too late because the family wasn't involved, the parents weren't involved. But it's never too late to be involved. And I know I have colleagues here who advocate for families. And so I know it's never too late to get involved in your children's lives. And hopefully this measure, Madam Speaker, if passed into law, can also be used in the future for, maybe this would be a starting point for parents who are not as involved in their children's lives, could be involved in their children's lives, to speak to them about the consequences of their acts, Madam Speaker. And so, as a backdrop to this, Madam Speaker, just very recently, the Health and Human Services Secretary, Kathleen Sebelius, overruled her FDA experts. The FDA was ready to lift the age limit on the Plan B morning after pill. What this Plan B morning after pill does is prevent pregnancies from happening within a certain amount of time. Right now, 17 minors who are 17 and older, individuals who are 17 and older, can go to a pharmacy and prove their age and be allowed to purchase this morning after pill. What the FDA was ready to do was to open it up and have this drug available over the counter. And it was the health secretary who overruled her own FDA experts, saying, and I quote, "Young girls couldn't properly understand how to use the Plan B one-step morning after pill without guidance from an adult." And you think about it, what's so hard about a pill? Taking a pill, I don't know, I'm assuming it's a pill, you take it just like any other pill. And if we're saying that they're concerned about young adults, minors, and taking this and being able to see how this one affects their body and their health, what more a procedure of abortion, Madam Speaker? And so I want to ask my colleagues, Madam Speaker, to please support this and consider this measure, and to really think that this is all about ensuring that our minors are protected and that the parents or their legal guardians or custodians are involved in what they do, Madam Speaker. I have a few amendments I'd like to propose, Madam Speaker. It's a total of 5 amendments, and I believe it's been circulated already. The first one is on page 8, beginning on line 15, subsection D of subsection 4407. If the court finds by clear and convincing evidence that a minor is, and we're deleting the word both, sufficiently mature, and we're adding the word or, well informed to decide whether to have an abortion, the court shall issue an order authorizing the minor to consent to the performance of inducement of abortion without the consent of a parent or guardian, and the court shall execute the required forms. And as much as possible, Madam Speaker, we try to consider and work with the testimonies that were provided to the committee. And so one of the lone oppositions to the legislation asked that we consider this. And so as the author, I like to make that amendment and ask my colleagues to please support
Is
it.
that where it says number 1 on the top
That's
left-hand
correct, Madam
corner?
Speaker.
Okay, so that's on page 5, line...
Page 8.
On yours says page 5, number 1, top. That's why I'm asking you, because I couldn't follow you. It says... Oh, okay. So I don't think I have... Oh, no, then I need to... I don't have,
No.
I'm sorry, your set of amendments. Okay, no, that's all I got. Okay, I'm sorry, Senator, then because the only one I saw is number 1, which is from Senator Blas. Okay, so the first one then is on page 8, line 15. So you're only deleting the word both. And changing the and to or. Okay. So on that amendment, is there anyone who would like to speak on the amendment? Amendment number 1? No objections to it? So ordered.
Thank you, Madam Speaker. I have a few more.
Okay, so the next one?
The next one is, I don't think, I think you have number 3.
I don't have number 2. So it's number 3?
Okay, so number 3, we'll jump over to number 3. And this is on page 10, beginning on line 1. And we're adding after that, that paragraph there, or that sentence there, the promulgation process rules shall begin within 120 days from the date of enactment of this act. And so what we're doing here is just putting a time frame on when the court should put together the established rules to ensure that proceedings under this act are handled in an expeditious and confidential manner.
On the amendment, no objections? So ordered.
On page 4, it's a typographical correction. Page 11, line 1, there was omissions on a few of the letters, and it begins on line 1. It's supposed to read, the act was a result of a simple negligence. And so we're adding the 2 letters C on act and W on was.
Where? Oh, wait. Oh, so wait, you've got one says page 8, line 18 first?
Page 11.
Yeah, you got page 10, line 8.
Okay, well, disregard that. That's
disregard?
that, yes.
Okay, so... Okay,
Yes.
so we're going to disregard...
The additions are what's underlined.
Okay, so then we're disregarding that on our amendments, and then, so we're going down to the next one, which is on page 11, line 1, and the act, okay, A-C-T...
The act was.
Was, okay,
And the first part is just to show how the sentence is supposed to blend in.
okay, I understand. So on the amendment, any objections? No objections, so ordered.
The next amendment, Madam Speaker, is on page 11, beginning on line 20. And the section, I'll read it, section 3, effective date. This act shall become immediately effective upon enactment, and this is what we're adding. Provided, however, the actual implementation of the provisions of this act shall not take place or be deemed to be in full force and effect until such time as the Unified Judiciary of Guam establishes rules pursuant to subsection 4408 of Chapter 4A as provided for in this act.
On the amendment, no objections? So ordered.
My last amendment, Madam Speaker, and I don't think it was passed. It says number 2 on top.
Yeah, we don't have a copyright of that. Is it a long one?
If I can just read it, and
Would you like to do that as part of your closing while somebody, or I can give you an opportunity to come back again if that is
Okay.
critical to the rest of the discussion.
Okay, it may be, if I may, Madam Speaker, so that if there's anyone else,
And
my
then-
colleagues that want to do it, then maybe we can correct it here now. I can just read it and then, and have one pass.
Oh,
It's up to you. I have no
yeah, I
problem.
mean, you can read it, and then if anyone would like to get
Okay.
a copy, then
Okay.
if
Yes.
it's long. Yeah, while you're reading it, we can be making copies then.
This is on line 9,
What
Um,
page?
page 9, I'm sorry, page 9, beginning on line 1.
Page 9, line 1, okay.
And it reads now, item E, if the court finds, and I want to strike out by clear and convincing, I want to strike that out and just put, if the court finds evidence that there is an incidence, and remove the word pattern.
And incidents?
Yes. No, if that there is an incidence.
That there is a incident?
Yes. And remove pattern
Or remove pattern?
of physical, sexual, or emotional abuse of the complainant by one or both of her parents, her guardian, or her custodian. And I want to add the following: or by a male person, regardless of the family relationship, if any, who has physically, sexually, or emotionally abused her or caused her pregnancy. Or that the notification of a parent, and I want to add guardian, striking out guarding, that's a typo, or custodian, is not in the best interest of the complainant. The court shall issue an order authorizing the minor to consent to the performance or inducement of an abortion without the consent of the parent or guardian, or parent, guardian, or custodian. We're adding the word or custodian, and then the rest remains. And and one of the reasons why I wanted to strike out by clear and convincing evidence, just put evidence.
Yeah, no, we're going to have to get a copy
Yes,
of this.
it's,
You're right,
they're
exactly.
being-
I'm allowing him just to go ahead and read it while we're getting the copies.
Sure, and it's being circulated now.
But you're right, this is I think now that we're going to get a copy, we're going to take a brief recess so
Okay.
everybody can read it and absorb it because it seems very deep. The legislature is back in session, and everyone should have a copy of the Rodriguez Amendment, which is on page 9 and starting with line 1. And does anyone have, would like to speak on that particular amendment? Is there any objection to the amendment? Hearing no objections, so ordered.
Thank you, Madam Speaker. And Madam Speaker, I have an amendment here from Senator Guthertz, who asked me to move it for her. She had to leave briefly, if I could, and I believe it was distributed.
Okay, it's just one handwritten amendment?
That's correct.
Okay.
And basically, one of the amendments here, Madam Speaker, is to delete the word notarized on the requirement
And
to.
what page is that? It just says line, throughout, but it says line, wait, section 4402, wait, there it is, 4402, which is on page 5, line 17, delete the word notarized.
Yes, and we can just delete that, and then if legal counsel can, it has to be.
So on line 19 as well, the word notarized to delete. And page 4403 section, line 4, notarized. Okay, so let's just finish all that for the notarize, the word notarize without any objections. So ordered. Okay, you may continue then. So now in section 4406.
4406, she wants to add that specific names of minors or of incompetent persons covered by this act shall not be included in the monthly report or on any similar report generated by the Department of Public Health and Social Services. I can't read the rest of her of this amendment, Madam Speaker, but I guess what she's saying is that, and I think that's what's being done now. There is a reporting requirement on the number of abortions that are performed, and none of those reports
or by any other instrumentality.
Okay, but none of those reports now have specific names, and so I guess she wants to be consistent and ensure that as we are requiring in this legislation to have some sort of requirement on the number of consents that were received, that to ensure that no minors' names or any names are included in that report.
Okay, so we're going to include then Senator Guthert's amendment to, at the end of section 4406, these words. Is that the amendment you're making, or you're saying to us that already it's covered?
No, that's her amendment, and so I'm
Okay.
going to move, yes.
So on the Guthert's amendment then, which is on section 4406, page 7, that means at the end of where it says the title reports is to add the following sentence. Any objections? No objections? So ordered.
Thank you, Madam Speaker. I'm done.
Okay, so that concludes your amendment. I do know that Senator Yamashita, you also have an amendment. Oh, wait, I'm so sorry. You're right. Before I ask you to give your amendment, because you're right, because I didn't see an amendment from the Vice Speaker, but you did raise your hand to speak. So yes, I'm sorry. I'm going to make him speak. Okay, Mr. Vice Speaker, and then I'll call Senator Yamashita on the amendments.
Thank you, Madam Speaker. Madam Speaker, this bill was heard by my committee, and we reported it out without any amendments, figuring that any amendments that can and should be made would be made openly here on the floor, so there'd be no allegations of some kind of action to try to change the intent of this bill. But, Madam Speaker, I have to rise in defense of the Guam Legislature. I cannot allow it to be said and for the community to believe that this legislature and the previous 30 legislatures before us have not done anything to make sure that no minor could go into any doctor's office or clinic and get an abortion without parental consent. That is urban myth, and it's patently false. After the hearing, I called the Attorney General and chastised him why there were no prosecutions for any of these, and they insisted there had not been any that they were aware of. I called the GPD, and they insisted they too had never had any reports of any minors going and receiving any abortion or any kind of treatment to induce abortion without parental consent. So I tried to figure out where this came from. Why this urban myth? And discovered it. Madam Speaker, in 1976, the 13th Guam Legislature copied the California Civil Code and enacted Chapter 19 of the Guam Code Annotated. And in it, they had on section 111A3 the following: medical care and services means the diagnostic, examination, prescription, and administration of medication and other items in the treatment of venereal diseases, pregnancy, and substance abuse. And I want everybody to understand the language I'm about to read was included in the 13th Guam Legislature's Act. It shall not include surgery or any treatment to induce abortion. So it included both the act of a D&C and the morning after, or whatever those other pills that was being talked about earlier. That was in the law in 1976. There may have been some misunderstandings because in 1994, the 22nd Guam Legislature, of which two of our members currently sitting, Speaker Pangilinan and Senator Ada, were members of the 27th Guam Legislature.
22nd.
They amended, made an amendment to Section 111 of 19 GCA. They made the amendment in 1994 because at that time there was an epidemic throughout the country as it relates to HIV and AIDS. And Dr. Leticia Espaldon, who was the Director of Public Health and Social Services, sent a letter down to the Guam Legislature imploring the Guam Legislature to enact legislation to allow minors to undergo examination and possible treatment of HIV without getting parental consent, because public health and social services and all the public health and social services people throughout the country felt that it was more important to try to make sure that HIV and AIDS was not spread by young people who were infected with the virus if they had to get parental consent and didn't want to expose the fact that they had been infected. So the 27th Guam Legislature passed Bill 704. The main sponsor was Dr. David Shimizu. The other main sponsor was Senator Marilyn Manibusan and Senator Tony Bloss. And it was unanimously passed by the Guam Legislature in 1994. The amendment that they included in 1994 was they included the words They struck venereal disease and instead put in sexually transmitted diseases, HIV, virus, or AIDS. The 22nd Guam Legislature did not, and I repeat, did not amend or remove the requirement that was stated in 111E that it shall not include surgery or any treatment to induce abortion. So since 1976 and reaffirmed in 1994, the Guam Legislature has made sure that no minor could go to a clinic or a doctor or wherever and get an abortion without having parental consent. Where the myth arose that it was happening, I've not been able to figure it out. But I supported and reported this bill out for one very specific reason, Madam Speaker. This bill includes the actions and the promulgation by the court of some rules and procedures in which to deal with this. For me, having served as a family court judge for 10 years, that section was a godsend. As you stated during the break, Madam Speaker, I'm actually only 34, but my hair is gray because of the fact that the stories that I heard while being in that position. And the stories that now just are coming out in the newspaper of a 38-year-old courting a 12-year-old. Our good colleague here was at the court at the same time that I was. And he can attest to the fact that he was in the court a couple of times when we had to deal with, and I even hate to use the word father, but a father sexually abusing all three daughters, and impregnating the 10-year-old. We've had them where it's multi-generational, where it's not just the grandfather, it's the brothers and the uncles, and everybody was having a heyday with the girls in the family. But there was no rules by which I could act. I only used the inherent powers that I had as the family court judge to hear these things and to appoint guardian ad litems for one and an attorney for the child and a guardian ad litem. For people who don't understand the distinction, when I appoint an attorney for the child, that attorney represents what the child wants. If the child says, I want this, I don't want to go through this action, or I don't want to do this, or I want to do that, or I want to do this, the child's attorney will represent to the court what the child's desires are. But I always also appoint a guardian ad litem, which is also an attorney, who comes in and argues in the best interest of the child, regardless of what the child wants or what the child needs. But there was a period, Madam Speaker, where I was being chastised because I was spending so much money on attorney's fees because I was appointing guardian ad litems and attorneys for the child and running up the fees because I wanted to make sure that the procedure was proper. And I want to thank the sponsor of this legislation for introducing the parts of this bill as it relates to the procedure for which the court is going to do this. Because now it puts it down in statute, in writing, a procedure, and it also invites and requests that the Unified Judiciary go through it, speak to all the judges that have served as family court judges over the last 10 years, 15 years since I left it, utilizing their experience and try to figure out the best way to be able to deal with this. And that, Madam Speaker, is worth even the allegation that the Guam Legislature has been derelict in its duty and been allowing minors to go in and have abortions without consent. There are other problems with this bill that I'm not going to speak to. I'm just happy that we're going to establish the procedure by which the court, the Unified Judiciary, makes these rules, and I will swallow the rest of the bill because I want the judiciary to write some regulations so that whoever becomes and has to serve that 1 or 2 years as the family court judge will have some procedure by which they know how they're supposed to be behaving and ruling and acting when it comes to cases like this, because it is unfortunate that it is not the exception. It is more common than we'd like to believe. And I applaud the fact that we're finally going to address it at this time with this legislation. But I just wanted to make it very clear, Madam Speaker, that this Guam legislature and our previous legislatures have not been derelict in allowing for abortions without consent by a parent, because it's specific in the law. It was reaffirmed when the 22nd Guam legislature amended it. And so it's there, and I've been trying to find somebody to come with names and dates where a minor got an abortion from a licensed doctor. I'm not saying that there may have been something that was done without, with someone who wasn't a licensed doctor, but according to the statute in 19 GCA, it has to have the consent. The only time that a minor can go in and get any kind of medical treatment without parental consent is for testing and treatment of HIV and AIDS, or testing and treatment for substance abuse to try to make sure they can stop it. So I just wanted to make that clarification and stand in support of the provisions of this bill that are going to allow the judiciary to write the rules that are going to be able to address this epidemic, this plague on our community. And so I thank you for the opportunity to speak.
Very welcome, Mr. Vice Speaker. On the motion, I have Senator Yamashita.
Thank you very much, Madam Speaker. Earlier this morning, I had passed out a few amendments, 3 of them, well, actually 3 pages. But some of these amendments have already been addressed by the author of the legislation. Before I go specifically into that, Madam Speaker, I want to say that I stand in full support of an intention of this legislation by the author, and that is to foster family unity and preserve the family as a viable social unit. Anything that we can do to help will help. Earlier, on a different bill, I had stated that many times mandates are just simply ignored, but many times mandates do help. But as I thought more and more about this, I was thinking maybe we're getting closer and closer to actually addressing the notion of required training for families, some type of certification to become a family member, parent. I suggest that being a parent is the most important job in the world, but it is also the one job where we all learn it OJT, on the job training. And for those of us who are fortunate, we have done fairly well, and then some of us have had more challenges. But by and large, our social fabric of our island is in need of help. We have abuse issues all over the place. We have families that are falling apart. We have big cries for help. But the issue right now is teen pregnancy and what we do with teen pregnancy. And perhaps we'll get to a point where in the notion of some sort of training or certification for families, that it's tied into health issues. Currently on our island, we all know we have about 300 births a year. 10% of those are going to teens, are to teens. We have, in 2006, we had 2 teens have abortions. 2007, that went up to 5. In 2008, for some reason, that spiked to 45 abortions of our teens between the ages of 13 and 17. 2009, it dropped to 17, and last year in 2010, we had 11. I would trust that those procedures were done with parents, family members with these children. Like you, Madam Speaker, I'm real familiar with the stories in our middle schools where we find out we're pregnant, and then it is, what is it that we do? It's a very sensitive issue, and it is an issue where we want to put in the kinds of safeguards to ensure that the rights of our growing girls and the rights and responsibilities of our families are intact. So as I read and reread Bill number 323-31, I thought that with some changes and amendments, I could stand in full support of it. I passed out again three pages of amendments. The first one is really technical, and again, the author has addressed some of them. But starting on page 6, I'm thinking that was actually addressed way at the top. It's not side, but it would be signed. On page 9, and I believe this is in writing, and I believe that the clerks have it. But on page 9 and line 3, that has been addressed. It's not guarding, but it's actually guardian.
Yeah,
Oh, sorry.
yeah,
Okay.
yeah. And maybe at this time also, I know that Senator Guthers didn't make that general amendment that, oh yes, she did, I'm sorry, that technical, corrections can be made. And if it's a misspelling, then of course the legal counsel can make that. So the first one we'll go ahead then, which is on page 6, line 1, you said the word, of course, changed to signed. ED.
Yes.
So with that, no objection, so ordered.
Page 9, the author of this amendment has already addressed the first two, that and guarding has been changed to guardian. That's taken care of. On page 9, line 22, not trail, but trial.
So on that amendment then without, no, it's this, yes. There are no, she's making the changes on page 9, line 4. Instead of guarding, it would be now guardian. No, not in mine.
But
Oh, yes, and she did mention that, but not the trail or trial. That has not been
Right.
mentioned. So that's on line 22. So yes, so and I just called for that, so that passed. You may
page
continue.
11, line 1, delete the.
11, line 1, delete the, okay.
And that's it for the technical.
On
the
that
type-
amendment then without any objections, so ordered. Okay, so that takes care of the first page. So now your second page of amendments are,
Okay.
yeah.
Wait, I was just.
Action may be based on the claim that the act was, or that act was the result.
Madam Speaker, I apologize. Because an amendment had already been proffered, that particular page 11, line 1 amendment is withdrawn. That language is
that-
fine.
Okay, so.
The word "the" belongs there.
So the word
Remains.
will be,
It remains because of an
remains.
amendment that the author had.
okay, that Senator
Proffer.
Rodriguez made, so, okay then, so it's so the word "the" then on top, on page 11, line 1, the first, then remains.
Thank you. Thank you. The second page of amendments that I'm asking for consideration, on page 5, line 4, we define sexual abuse and who it relates to, and the author had talked about Chapter 25, Title 9 GCA. And that definition actually is by a family member related to the minor by blood or affinity to the fourth degree to the victim. That's not, I'm not asking for amendment, but I'm simply saying that I spell that out and that's what it means. And when you go throughout the measure, it kind of changes from that to a parent to a guardian. And what I'm suggesting is that wherever we find that context of sexual abuse by, I'm asking that we consider it always be by a family member related to the minor by blood or affinity to the fourth degree of the victim. And the only other place I really found that was on page 6, line 3.
Page 6, line 3 is we're to add that.
So instead of,
Sentence.
it would be abuse by a family member related to the minor by blood or affinity to the fourth degree of the victim. And Madam Speaker, the reason I asked for that consideration is, yes, it is true, unfortunately, sometimes parents or legal guardians are the abusers, but sometimes it's also other family members.
Okay. On the amendment. On the amendment. You have a question? Can you please?
Madam Speaker, if I may, I just want to, based on the amendment as being proffered by the good senator, I just want to make sure that, as it states right now on page 5, it is as defined by Chapter 25, Title 9. And if we are going to change it, it should show the
No, it's not, she's not changing it. It's this, the bill cites the actual code.
Right, but she's saying
But
that it should read this.
But, you know, but this is exactly what is in the code. So when you go to
Page 6, line 3.
page 6, line 3, she's asking that instead of this repeating the code, that you actually put this definition
That's,
in line
okay.
3, page 6. Is that correct, Senator?
Yes.
Right, instead of citing the code,
Instead-
just to
yes.
specifically state it.
Yes.
Yes.
Okay, thank you, Madam Speaker.
Very good. So
Thank you.
on that then,
Thank you.
amendment without any objections? So ordered.
Thank you, Madam Speaker. And then the last one I had was actually already addressed by the author of the measure, and that was to ensure that the judicial bypass is actually addressed and adjudicated, promulgated before the act goes into effect. Thank you very much,
Okay.
Madam Speaker.
You're very welcome, Senator. On the motion, the main motion, anybody would like to speak? Okay, I see somebody waving back there. Gosh, so many amendments. Okay, Senator Frank Blas Jr., did I see your name in here? Okay, yes, you are recognized. Only 5?
4.
4? Okay, let's get going.
Thank you, Madam. Thank you, Madam
Okay.
Speaker. And I want to thank the good chair of the committee that had oversight over the process and being able to share some of the information and some of the testimony that was provided. And I already know that. And so,
Okay.
Madam Speaker, along those lines, and for the sake of recognize, you know, what the bill is and what the bill is for, and I appreciate and applaud the author for introducing and presenting the bill that's before us. I recognize, Madam Speaker, that the best way to make a decision is to have an informed decision. And one of the things that I wanted to do in proffering the amendments that I'm about to proffer is to ensure that it does provide the information necessary to make that informed decision. And so, along those lines, Madam Speaker, I'm sure that all of my colleagues have copies of 4 different amendments that I'm going to proffer. They're all marked at the top left-hand corner too, numbers 1 through 4. And for the sake of being consistent, or you know, so that we're not losing, I'm going to skip. I'm going to go 1, 4, 2, 3, in as far as offering the amendments, so that we don't have to go back and forth as far as the pages. The first amendment, Madam Speaker, that I'd like to proffer is for page 5, starting on line 21. In the section for under the consent of one parent required, on line 21, or let me start where it says, it starts to read on line 20. In deciding whether to grant such consent, a pregnant woman's parent or guardian and I understand that we have already made the amendments to say parent, guardian, or custodian, shall, and the language that I want to insert here is, be advised of the risk involved in the abortion procedure and the risk of postpartum syndrome and alternatives to the abortion, and shall consider only the child's or ward's best interests. So it's adding the words, be advised of the risk involved in the abortion procedure, the risk of postpartum syndrome, and the alternatives to the abortion. And Madam Speaker, the reason why I'm proffering this is in order to make an informed decision. These are the requirements, the information required to be presented to the parent, the guardian, or the custodian, so that when the decision is made, it is an informed decision.
On the amendment, any speakers? Hearing no objections, so ordered.
Thank you, Madam Speaker. Madam Speaker, the next amendment that I'd like to proffer is on page 7. And actually, this is amendment number 4.
Number 4, not number 2?
Well, let me start with number 2, actually, because what number 2 will do is, first, it would make that whole paragraph under the reports that is originally there, subsection A, and then I want to add, after that subsection A subsection B, which would read, the Department of Public Health and Social Services shall develop the forms necessary to gather the information required by this section within 60 days of the enactment of this law.
So, okay, so then where it says on line 14406, reports, that would be an A.
That would be an A, and then there will be a
And
B.
then you're going to be adding a B, and that would include then, so at the end of, not at the end of line 8, but after line 8, there'll be a new subsection B to read then the Department of Health shall
Right.
develop these forms.
Yes,
On
ma'am.
the amendment, no objections, hearing none, so ordered.
The next amendment that I proffer, Madam Speaker, is actually now amendment number 3, and that again is also found on page 7, and it starts on line 16, and that is to add, after the word waived on line 16, a comma, and then the words, that the pregnant woman has been advised by her attending physician of the risk involved in an abortion and the risk of postpartum syndrome.
Are we talking about an adult woman or a child here?
This is the pregnant woman. This is the child.
So, pregnant woman or pregnant minor? So, that the, okay, wait. Can we take a brief recess? At the end of line 16, where the word waived,
Right.
put comma.
Comma.
That's for the clerk's purposes, okay?
Okay.
And then the amendment continues.
That, and Madam Speaker, thank you for the recess. And I want to make an amendment to this amendment. It says, that the pregnant minor,
Has been advised by her attending physician.
right.
On the amendment, no objections, so ordered. Thank you, Senator.
Okay.
You have
And the
another
last
amendment? Another amendment?
Is the last one, ma'am, is actually going back up to the reporting, the reports, section 4406. And it goes on line 5, where it says, abortions of the minor shall be filed, after the word filed, to include the words, by any physician performing any abortion or procedures to induce abortions.
So
This will hopefully satisfy the requirement as to who's required to file reports.
Okay, on the amendment then, which is on line 5, page 7, after the word filed, add the following words, by any physician performing any abortion or procedures to induce abortions with the Department of Public Health. Okay, so on the amendment, hearing no objections, so ordered.
Thank you, Madam Speaker. That's all I have, Madam Speaker. Thank you very much.
That's it, okay, thank you. On the main motion, are there anyone else who would like to speak? Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in support of Bill.
One moment, Senator, please. There's too many discussions going on, and please respect the senator that's speaking. Thank you. Senator, you may continue.
Madam Speaker, I rise in support of Bill 323. This bill, Madam Speaker, assures that parental consent, parental guidance and supervision over a minor, especially involving medical procedures, would always be solicited, would always be required. I understand that there are currently laws, Madam Speaker, that require parental consent for some even minor medical procedures, flu shots and the like. And I'm just surprised that, not surprised, but I think that this bill, while it might appear duplicate, I would look at it as strengthening what we already have. So Bill 323 is nothing new. However, Madam Speaker, the subject matter is so important, and we take the time to debate this, and it appears to me that the issue before us is a serious issue. It's a serious policy matter. And so when I look at the penalty side on page 10, line 5, I like to propose an amendment on line 9 and strike misdemeanor and replace it with a felony in the 3rd degree. I understand that is the lowest level of felony that can be had. Why is this, Madam Speaker? Madam Speaker, this penalty would appear to commensurate with what we are proposing to protect, and that is to protect the minor and, of course, to protect the integrity of the procedure. If you look at, beginning on line 5, any person who intentionally perform an abortion with knowledge that or with reckless disregard as to whether the person upon whom the abortion is to be performed is an unemancipated minor or an incompetent minor without obtaining the required consent is guilty only of a misdemeanor. And that is why, with all these requirements, misdemeanor, Madam Speaker, involve not to exceed 1 year in prison and not to exceed $1,000 fine. That's the highest level of a misdemeanor. And to me, it appears to me that does not match what we are trying to do here. At least personally, the way I see this is a serious matter. It's a serious issue. And to me, at least a 3rd degree felony would carry sufficient deterrence that would cause one to hesitate and wonder really whether they'll go ahead and perform a procedure that might be irreversible once it's done. And that's really my concern. And so I am proposing, of course, to change that on line 9, misdemeanor, and replace it with a felony in the 3rd degree. And I just want to add that the second amendment that I would like also has to do with the second procedure. With
Oh, one moment.
I
I'll
understand,
call
but
for
I'm
the
just
vote.
carrying on that.
Yes, thank you, Senator. I know you're excited about this. On the motion then, which is then to, on page 10, line 9, to delete misdemeanor and replace it with felony in the 3rd degree. No objections? No, so ordered. Oh, our
And
officers here are in.
My second amendment, Madam Speaker, is the same on page 11, and that is on line 7. Any person not authorized to provide consent under this act who provides consent is guilty of felony in the 3rd degree. And this has to do with faking a consent simply. That's what it's all about. Again, once a consent is given, it is to be taken by the performing physician as bona fide. Once a procedure is done, again, it's irreversible. I differentiate item C on line 7 with item D on line 9 because line 9, it just say a person who coerces a minor. There's still one more step after coercion. The minor still would have to, even if he's coerced to get a procedure, the minor still has to get the consent. And that's why I did not make any proposal to make that a felony, because that one I think matches the misdemeanor level. But for the C, again, I would like to replace misdemeanor with felony in the 3rd degree, Madam Speaker.
Okay, so to be consistent then, page 11, line 8, to again delete this misdemeanor and replace it with felony in the 3rd degree without any objections, so ordered.
Thank you, Madam Speaker. That's all. Thank you very much.
Thank you very much, Senator. So on the motion, main motion, is there anybody else who would like to speak? Okay, so the author, would you like to close?
Thank you very much, Madam Speaker. I want to thank my colleagues also for rising in support of this measure, and I believe we are one step closer to truly protecting our minors. There is just one aspect, though, Madam Speaker, I'd like to clarify. It's something that was discussed here on the floor, and also something that was reported in a local media, newspaper media this morning, that existing statute already is in place that will require a minor to have a consent, a parental consent before abortion is performed. Well, that's not truly the case. That Title 19 of Guam Code Annotated, Madam Speaker, does define what medical care services are, and it says there that the minor, that services means diagnosis, examination, prescription, administration of medication, and other items in the treatment of sexually transmitted diseases, the HIV virus or AIDS, pregnancy, and substance abuse, and shall not include surgery or any treatment to induce an abortion. And that alone, some may interpret that you must obtain a consent. Where nowhere in the statute is it there right now that what this bill is trying to do, and make it mandatory that if a minor is to seek this procedure, that you must have a consent, a parental consent. And so that's something that I would like to put on record. And once again, thank my colleagues for rising in support, and ask all my other colleagues to please consider voting favorably on this measure. So thank you very much, Madam Speaker.
Can we take a brief recess? Legislature is back in session, and I recognize the author.
Thank you, Madam Speaker. Just an amendment on page 5, line 4. We want to change the word conduct to contact, sexual contact, and that is just making it consistent with 25.10A8 of Chapter 25, Title 9.
Thank you, Senators. On that amendment then to change the word from conduct to contact. That's consistent with the existing GCA. So on that amendment, without any objection, so ordered. So on the motion then to send Bill 323 to the third reading file without any objection, so ordered. It is now, what time do we have over there? What time? Okay, yes, I think we'll recess until tomorrow morning at 9.